Today I want to talk about a very important topic when it comes to dealing with your DUI case. The most important part of any DUI case at trial for a defense attorney and the defendant is the cross-examination of the police officer. Most DUI cases start with the prosecutor putting on a case where he has the officer testify to all the observations he's seen and try to prove you guilty. It is after the prosecutor gets to have the police officer testify that the defense attorney can then go up and he gets to question the police officer. There's 4 critical things that any DUI defense attorney should know in regards to cross-examining witnesses. The first of which is the DUI defense attorney should be familiar with the National Highway Traffic Safety Administration Handbook. This is commonly referred to as the NHTSA Handbook. What this is a guide for all police officers to use in order to learn how to conduct standardized field sobriety tests and learn all the rules and regulations in regards to those tests. The 3 common tests that are used in any DUI investigation is the horizontal gaze nystagmus test, the walk and turn test, and the one-leg stand test. Each one of these tests has separate rules and requirements in order to be done and conducted properly. If your DUI defense attorney is well versed in these laws and regulations, he will know whether or not the police officer conducted the test properly, and he will be able to cross-examine the officer and show to the judge that these tests should not be used against you and should be given little to no weight because they weren't done properly, and that way they cannot properly show that you were under the influence of alcohol. The second and very important thing as well to know is a good DUI defense attorney should be very familiar with all the police reports that are being used against you and all the videos in your case as well. The police reports are very important. Officers are trained that they must record and put down all the very important details in any investigation, and the video shows exactly what happened. A good DUI defense attorney will know the reports so that when an officer goes up and testifies on the stand, he can point out inconsistencies between his report and between his testimony up at trial. Remember that an officer will write a report days, if not hours, after the incident happened, but the trial may not happen for 6 months to a year after you've been arrested. So the report should give a more accurate reflection of what happened than his testimony. If there's something that he's testifying to that's not in his report, that doesn't look well for the prosecution or for the officer. The third thing that's very important to know, of course, is DUI law. There's 7 different ways that you can be charged with a misdemeanor DUI. Each one of those 7 different ways have different elements. You can also be charged with a felony DUI, which would require additional elements to be charged as an enhancement for the felonies. A good DUI defense attorney will be able to look at the elements and make sure to hold the prosecution to their burden and to meet all those elements. Remember that in any DUI criminal trial, it is the prosecutor's job to prove you guilty beyond a reasonable doubt on every single one of the elements. A good DUI defense attorney will know the elements, and he will know how to attack the elements so that the judge can find you not guilty. The fourth thing, and also very important to know, is of course the rules of evidence. You want to make sure that the judge is only hearing relevant and admissible evidence. You don't want the prosecutor to give evidence that the judge should not be here that could potentially bias him and make him believe that you were drinking when that evidence should have never been introduced in the first place. If a defense attorney does not object to that evidence, the judge will be able to hear it. Even if the judge allows that evidence in and you believe he shouldn't have, a good DUI defense attorney will be able to effectively cross-examine the police officer and show to the judge that this officer does not maybe have firsthand knowledge of that. One common example I give to a lot of people is when a police officer gets a call over the radio from a concerned citizen that someone may have been drinking. If the police officer then testifies at trial, I got a call that someone was drinking, that's normally what we consider hearsay. If for some reason the judge lets it in at trial, a good DUI defense attorney will be able to show that this officer does not know whether or not this person was drinking based off that statement. They don't know who that person is, and they don't know why that person believed that you were drinking. All 4 of these things are very critical in order to conduct an effective cross-examination. You want to make sure that your attorney can do all these and he's well versed in all these areas. Once again, he must know all about the National Highway Traffic and Safety Administration Handbook. He has to be well versed in the reports and the videos and know those as well as possible. He has to know DUI law. He has to know it as best as possible. He also needs to know the rules of evidence. Those are all very important. And if all those are known and your DUI defense attorney can get all those down, he should be able to do an effective cross-examination to give you the best possible chance to beat your DUI case.